tomorrow, and then, I'm going to tell Mr. Henry this as well, but for his benefit now, if he wants to resolve the cases by way of a negotiated plea, that's fine with me. And if he doesn't want to, that's fine with me too. But the one thing that I am going to change, if you need me to, I can put him on maybe Tuesday afternoon, the 9th. I'd rather just not do it. I'd rather know yes or no the day before, because there's a significant, number one, I don't want him to feel any pressure. But number two, I got 250 citizens coming in here Wednesday morning, and there's just,
Tuesday afternoon is fine, Your Honor.
yeah, if need be.
I have a hearing at 3:30.
It's fee hearings, you know.
Yeah, so I don't really have to say.
But I'm going to be here, right?
Yeah.
Okay. All right, so Mr. Henry, listen, I'm going to put you under oath and ask you some questions, okay? It's only going to be as it relates to the state's offer, and it's only as to make sure that you understand the state's offer and you understand the charges that you're facing here. We're not going to talk about anything else. So just listen to my questions and answer the questions, okay? Raise your right hand. You swear to tell the truth, all truth, nothing but the truth. Okay, you can put your hand down. Please state your full name. How old are you? How far did you go in school? Do you read and understand the English language? Are you presently under the influence of any drugs, medication, or alcohol? Have you ever been treated for a mental illness? Are they giving you any medication in the jail right now? All right. How are you feeling this morning? Your head is clear? You understand what's going on? All right. So, Mr. Henry, listen, you got two cases. I'm going to go one at a time. In case number 19-1871 CF10A, right now, you're charged as follows. Counts 1 and 2 is murder in the first degree with a firearm. Those are capital felonies, which means it's a mandatory life sentence. If the jury convicts you of count 1 or count 2 as charged, that's life in Florida State Prison. I have no discretion. Count 3 and count 4 are accessory after the fact to murder in the first degree. Those are each first degree felony. The maximum penalty for each of those is 30 years in Florida State Prison. Okay. In your other case, which is case number 23-10643 CF10A, you're charged as follows. Count 1 is tampering with a witness in a capital felony. That is punishable by life in Florida State Prison. All right. As the maximum penalty. Count 2 is directing the activities of a criminal gang. That's a first degree felony punishable by life. So the maximum penalty there is also life in Florida State Prison. Count 5 is conspiracy to commit tampering. And again, as it's charged, that is also a life felony. The maximum penalty is life in Florida State Prison. And lastly, count 7 is unlawful use of a two-way communication device. As that's charged, the second degree felony. The maximum penalty is 15 years in Florida State Prison. So right now, as to all the charges that you're facing, the maximum possible penalties are as follows. It's life in Florida State Prison, followed by 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 75 years in Florida State Prison. Do you understand the charges and the maximum possible penalties involved? Okay. So, Mr. Henry, the state is telling me that they're extending an offer to you, and the offer is as follows. In case number 19-1871 CF10A, they're going to null process or drop counts 1 and 2, both first-degree murder charges. Okay, and in exchange for that, as to counts 3 and 4, in that case, the accessory after the fact to murder in the first degree, you're going to plead no contest to both of those. And as to the 4 counts in case number 23-10643 CF10A, you're going to plead no contest to all 4 of those counts. And in exchange for all of that, the state is offering that I would adjudicate you guilty and sentence you to the bottom of your sentencing guidelines, which is 195.45 months, about 16, it's a shade over 16 years and 3 months, 16 years and 3 months. All of those sentences will run concurrently, that is at the same time with each other. I would give you credit for all the time that you have served, understanding that you have a lot less credit time on the 23 case because it's a newer case. So that is what would be controlling. Whatever credit time you have on the 23 case, you could subtract that from the 100.
I think he actually has more time on the 23 case than the 19 he's at in custody.
Oh, okay. Well, whichever case you have more time, less time in custody, that's what would happen. And you get the credit for all the time that you've served. And again, that sentence would be 16 years, a shade over 16 years, 3 months in Florida State Prison. I would have to order restitution. The state would tell me the amount of that restitution. That restitution would be joint and several with any of your other co-defendants. If any of the other co-defendants were convicted at trial or entered pleas. In other words, the restitution only has to be paid once, but each person's responsible for 100% of it. All right, but as soon as it's paid, it's paid. I would have to impose mandatory court costs in each case, and I would have to impose a mandatory cost of prosecution in each case, which is $100. So, Mr. Henry, do you understand the offer that the state is making to you? Okay, the 16 years, 3 months, and a shade more. So I'm going to pause on it at this point, Mr. Henry. It's going to give you some time, whether that be tonight or also over the weekend, to talk to your lawyers about it. Make sure they answer all your questions, talk to your family about it so you can make a decision as to what you want to do. Now, let me explain this to you, sir. I can't make the state make you an offer, and I can't make you accept any offer. I'm just the referee, okay? This is a business decision between you, your lawyers, and the state. And if you want to accept it and resolve both cases that way, that's fine with me. And if you want to have a trial in both cases, that's fine with me too. It doesn't matter to me in any way, shape, or form. But whether it be tomorrow, when I see you tomorrow, and then Ms. Wilcox, she already has tomorrow at 9 o'clock, that'll remain on. But I'll put them on both cases as well next Tuesday, which is September the 9th. Let's just call it 1:30 in the afternoon. September the 9th at 1:30 in the afternoon. We'll call it trial status in both cases. That's when we're gonna have to finish this conversation, Mr. Henry, and you're gonna have to tell me that either that you understand the offer that the state's making, that your lawyers have answered your questions about it, and then you're gonna have to tell me what your decision is, whether you want to accept the offer or whether you want to reject the offer. Mr. Henry, the one additional thing that I like to talk to people who are sitting in this situation that you're sitting in right now to have this conversation is as follows. The reason that I'm doing this is because I want the record to be clear what the state's offer was, and the record to be clear that you understood it and that you had enough time to talk to your lawyers about it. You had enough time to talk to your family about it. You weren't under any pressure to make a decision, whatever you thought was in your best interest, because it goes kind of like this. And I'm sure your lawyers could speak to it better than I can. If you accept the state's offer, that's fine. And again, if you don't accept it, that's fine too. But if you don't accept it, and one of these trials doesn't go your way, and you end up with life in Florida State Prison, which is a mandatory sentence on a lot of these counts, usually people in that situation, then they'll file what's called a motion for post-conviction relief, and they'll say, hey, Judge, my lawyer never told me. I didn't know that I could resolve all this for 16 years and 3 months. And if they would have told me that, I would have done it. And now I'm sitting here with a life sentence. So that's the reason I'm having this conversation now. So the record is going to be crystal clear on that issue. If it doesn't go your way, that argument's not going to be available to you to come back and say, hey, my lawyers didn't tell me about this, or I didn't know about this. So that's why I'm talking to you about it now. So, Mr. Henry, do you have any questions for me about the maximum possible penalties involved and what the state's offer is to you as we're talking about it right now? Okay. All right. So I'm going to pause on that part of the conversation, and we'll finish that other part of the conversation either tomorrow or next Tuesday afternoon. I'm going to leave you on for tomorrow, all pending motions, which is September the 5th at 9 o'clock. I have one other matter that I need to handle prior to that with Mr. Gibson and Mr. Percio. I don't imagine that's going to take too long. And then I'll be right with you all tomorrow. And then Ms. Wilcox, we're going to put both of Mr. Henry's cases on Tuesday, September the 9th, 1:30 p.m. We'll call that trial status, and he remains set for trial in both cases on Wednesday, September the 10th at 9 o'clock, understanding that if we go forward with the trial, it's going to be on the murder case, the 19-1871 CF10A. State, is there anything else that you need me to do regarding Mr. Henry today? Mr. Haddad, anything else you need me to do regarding Mr. Henry today? Okay. All right. So we'll press pause at that point, Mr. Henry. I'll see you tomorrow at 9 o'clock, which is Friday, September the 5th. Ms. Wilcox, does that otherwise conclude the FT docket for today? Okay. So the FT is otherwise going to be in recess until tomorrow, which is Friday, September 5th. At 8:45 a.m. I hope you all have a good rest of your afternoon. All right, Mr. Court Reporter. That is it.